everybody, and welcome to Civil Rights and Civil Liberties for summer 2023. I do these introductory videos for all of my online courses just so students can have a face that goes along with the name, and just to also let you know that I'm the type of professor who tries to be approachable and welcomes interaction and questions and things like that. So that brings me to the other purpose for this introductory video, which is to give you 3 do's and 3 don'ts. And I'll try to make this brief. So the first do is do ask questions. Sometimes, this happens to me too. We try to be independent and do everything on our own, but certain topics like civil rights and civil liberties, since they're based on the Constitution, some topics can be somewhat complicated. You're going to have to reach out and ask questions. So don't expect to figure out anything and everything on your own. I will post office hours on the Blackboard page, as well as a Google Voice number where you can text me, and you can always ask questions by email. So do ask questions. The other do is to not hesitate to use online tools that can be helpful. And I'm not talking about ChatGPT, because it's good for some things, but not legal stuff. And I'll talk about that in a minute. What I mean by that is don't be afraid to use different resources that can help you understand constitutional law above and beyond resources that I might provide. So one thing you'll see I'll point you to is a website called Oyez, oyez.org, oyez.org. And some people look at Oyez as a cheat site for constitutional law because it translates all of these difficult Supreme Court cases into really quick summaries, kind of like Cliff Notes. So it might sound kind of funny for a professor to tell you to look at this thing that's the equivalent of Cliff Notes, but I'm not hesitant to do that. I'll even link it as a resource on all of your online materials because it's great to use to get an overview of what you're reading. The summaries on Oyez aren't going to be the only thing that you have to look at or use, but hey, it's a resource that's out there, and if it can give you a quick overview of what you're supposed to be looking for, then why not use it? I use it all the time, just as one tool, right? It's not a substitute for doing the work. The last do is to actually use the online free digital textbook I give you. Some people try to get by just looking things up online, and there's a lot of bad information out there about constitutional law. So you want to read the actual cases that are in the free textbook, and don't worry, they're not the whole Supreme Court cases that are like 100 pages long. They're just the meat of the case, so like the 10 or 15 pages that are the most important. So that leads me to the 3 don'ts. You'll notice, like a lot of online courses, you have a deadline every Sunday, and I would highly recommend that you don't leave everything till Sunday night. And I know that's hard to do, and that a lot of people succeed in online courses doing that. It's really tough to do that in a summer course where you have a 15, 16-week class squished down into 6 weeks. And then on top of that, the topic matter can be kind of dense. So give yourself little deadlines on your phone calendar or your agenda, whatever you use to keep track of your time, to do certain chunks of tasks midweek and then finish up on Sunday night. If you, leave everything till Sunday night, you'll end up getting mad at yourself and mad at me, and that doesn't really serve a purpose. So the second don't is to not skip the videos. The videos are kind of long, and the reason why they're long is because I'm trying to synthesize and help explain somewhat complicated concepts in a way that I know will be helpful to you. And I've been doing this for a number of years, and it takes some time to explain things and break things down. It's kind of asking too much of yourself to, expect yourself to understand and master introductory civil rights and civil liberties in 6 weeks without any guidance from a professor. And those videos are what my guidance is. And over the years, by trial and error, I found out the best ways to break things down to students based on their feedback. And I think I do a pretty good job breaking things down. Certainly let me know if I'm not and ask questions. But the videos will be really useful. And I've had students tell me, when they take the time to watch them in little chunks, that they've been very useful. So break it up into chunks and actually, watch the videos, don't skip them. And the last don't is about using Chat GPT. I've had to revise all of my assessments because Chat GPT and other AI resources can answer true, false, and multiple choice questions. So I won't have very many of those. They'll mostly be open response, and they will ask you to do things that Chat GPT can't do, like incorporating your own perspective and experiences and things like that. I actually devised my new assessments, getting some tips and pointers from Chat GPT about how to make things more robust for students and not things that they could quickly get from AI so that you're actually learning something. So I used Chat GPT in order to devise questions that couldn't be accessed from Chat GPT, which sounds funny, but hey, I figure if you can't beat them, join them. So anyway, that's my introduction. I'm going to transition to the actual lecture video now. And our first session here will probably last, about 45 minutes, which I know seems like a really long time, especially when, if you're like me, you watch TikToks that are 1 minute long, and some of those you skip through because they seem boring at the beginning, right? So 45 minutes seems like way too long. However, if you think about it, we have 15, 16 weeks smushed into 6 weeks. And the purpose of these video lectures is to save you the hassle of having to do a whole bunch of reading. And what I'm doing is saving you time from reading a lot by summarizing it. And also, some of the stuff is kind of complex. So even if I were to assign you a reading, I'd want you to have some more explanation instead of just throwing the readings at you and not giving you any guidance. So in other words, it'll be worth it. Break it up into chunks. Please do go through the whole thing. All right, so here's our agenda. I know you all can read, so I'm not going to read all 10 items for you, but you can see that this matches up with the week 1 folder in the little week 1 module there on the Blackboard shell. So we'll be going through these items. All right, so if you want to know a little bit about me, I'm not going to take up a lot of time here telling you about me because there's a link you can click on the Blackboard shell. But basically, I'm somebody who practiced law for a little over a decade, and then I've been in teaching for about a decade, and this is one of my favorite courses to teach. And speaking of this course, we have a much more lively and relevant course than ever because of everything that's going on with the Supreme Court. So I'm addressing things out of order. I'm not going to go First Amendment, Second Amendment, Third Amendment, Fourth Amendment. I'm going out of order on purpose based on what's in the headlines and what I know citizens are concerned about. So there's a method to the madness. Don't mind me addressing things out of order. We'll get to all the important stuff, but just out of order a little bit. As far as main expectations, it sounds kind of silly for me to say, read the syllabus and watch the videos, but the small fraction of the time I have students who run into problems, that's basically the reason why, is that they didn't read the syllabus and they don't know some basic stuff and that they didn't go through the videos. So they were just, Googling the answers at the end of the week and not really getting the meaning of things. So make sure just to follow along. so that you're not just kind of left on your own trying to figure things out by Googling answers. As far as resources, again, that's all spelled out in the syllabus, which I do ask you some questions about on your first test. And I know that seems silly, my apologies, but it's the only way I can get people to read it. One of the most important things you'll see, or important resources, is this website called oyez.org, which is oyez.org. And when you get on the website, you'll see one of the main features is that in the upper right-hand corner, there's a search box where you can enter the name of a case. Make sure you spell it right. And you will see the result is a brief of the case. And basically, a brief, it can refer to a number of different things, but in this context, a brief is a big, long Supreme Court case broken down in a nice, neat little summary. So instead of reading, 30 pages of a lot of legal jargon, you can see a brief where they have the facts summarized, what happened in the lower courts, going all the way up to the Supreme Court. And then they specifically identify the constitutional issue that the Supreme Court had to figure out. And then they give you the result and the analysis and all of that. And in some contexts, it might be cheating to just use Oyez and not read the case. I do urge you to read the cases also, because some of the questions you'll see the Oyez brief is not enough. But I don't consider using Oyez cheating in this class because it's not a legal research and writing class. So I'm teaching you about your civil rights and liberties, not really how to read Supreme Court cases. We'll kind of get there throughout the semester, but that's a pretty tough thing to learn how to do. And that's something that's arguably a junior or senior in college level activity. I've taught graduate level courses where people who have their master's degrees in English have a tough time reading Supreme Court cases. So giving you a helping tool is not cheating. And as far as what the heck's going on with the Supreme Court, well, I have lots of ideas and opinions and theories, and you may or may not too. But there's a whole bunch of stuff going on as far as Roe versus Wade being overturned, a lot of changes with the First and Second Amendment. So really the only logical and organized way to deal with that is to just take things one at a time, which you'll see that we do as we go through the course. So for example, next week, we'll be covering the case Dobbs versus Jackson, which overturned Roe versus Wade and what that means. Of course, first I'll give you some context about, what Roe versus Wade is all about and everything. So we'll get to all that good stuff. And then the final expectation is that if I'm telling you something that you didn't already know, that's new information to you, or you're saying to yourself, wow, that really clarifies this issue I've been concerned about. And that thing you're hearing isn't typed on the slide, then you want to write that down, because then when you go to do the test, you're not going to have to go flipping back and forth in the video. So if you have issues with note taking, shoot me an email. I can give you some resources, but it's an important skill to have as you go through school. And if you're like me, the little bit of an issue is, I want to write down everything. Everything sounds important. There's a learning curve to it. And everybody has trouble at first. So if that's an issue for you, let me know. I'll send you some resources. All right. So getting into the actual substance of the course, before we start analyzing Supreme Court cases, one of the things that we want to give some context to is the Constitution itself. And the beginning of the Constitution spells out Articles 1, 2, and 3, and that's our main structure and form of government. So what I'm going to be doing for the next couple slides is sort of translating the Constitution. Your reading assignment this week is to read the entire Constitution, which is all of the articles, which are different from the amendments. You'll see the articles spell out structural and foundational things, and amendments spell out civil rights and civil liberties. and it's about 20 pages. It's a PDF linked in this week's folder. And I am going to, as I said, translate it for you, for lack of better terms. But you still do want to read it, because think about it. Do you want to go through an entire civil rights and civil liberties course without reading the Constitution? That's the governing document of your nation. No, probably not. So hang on, my dog. All right, sorry for that interruption. So, Articles 1, 2, and 3, you probably remember from high school or earlier in your educational career. Um, Articles 1, 2, and 3 spell out the legislative branch, the executive branch, and the judicial branch, with Article 1 referring to Congress, the House of Representatives, and the Senate, and Article 2 referring to our executive branch, which is the president and the vice president. Technically, all our federal agencies, like the IRS and the FBI, belong under Article 2 also. And Article 3 is the judicial branch, which is the Supreme Court and all of the federal courts that fall under them. Keep in mind that each state also has its own version of Articles 1, 2, and 3, and each state also has its own constitution. So, for example, here in Massachusetts on Beacon Hill, we have our own legislature, we have our own governor, and we have our own state Supreme Court, which is known as the SJC, the Supreme Judicial Court of the United States. I'm sorry, the Supreme Judicial Court of Massachusetts. So, the reason why I mention that is because we do live in a federalist system. And as we go through the course, sometimes you will see that the issue of who has the authority over a situation, the states or the feds, becomes a real issue. And it's becoming more of an issue politically in the United States now. So, and as far as historical context, although this isn't a history class, you'll end up being reminded of history class as we go through. Because, for example, when we cover the post Civil War amendments and when we cover the amendments that came out, you know, later on, you will see when civil rights emerged, hey, back when the Constitution was written, they really weren't intending any of these rights to apply to enslaved people, to apply to women, to apply to poor people who didn't own any property or have any income. So keep that in mind too, because sometimes it's puzzling when you read the beautiful, flowery language of the Declaration of Independence and the Constitution, and then you get to the part where they considered some of our fellow human beings only two-thirds of a person. That can be a little bit puzzling. So you have to remember the context of who they were intending for these rights to apply to. I guess the only plus side to looking at that, for another way to put it, is that at least there was a system created where we could amend the Constitution, which we'll get to amendments in a minute. As far as the other articles, some people forget that we have articles besides Articles 1, 2, and 3. So, Article 4 spells out the full faith and credit principle that we have here in the United States. I apologize, I have hiccups. Full faith and credit refers to the practice we have in the United States where, for example, I'm married here in Massachusetts, so that marriage is recognized in New Hampshire. Just like if I got divorced in New Hampshire, say instead I lived in New Hampshire, got divorced in New Hampshire, that divorce decree would be recognized in New Jersey. We'd still be officially considered married and divorced in all 50 states. Article 5 refers to how the Constitution gets amended, and you will see the details of that on the next slide because we kind of need a visual aid to go through that. Article 6 spells out the Supremacy Clause, which a lot of you know says that when federal and state law conflict, federal law prevails. Sometimes we'll see instances where that doesn't happen, and it's not really because the Supremacy Clause isn't at play. It's because, for example, a state might want to offer citizens additional civil rights and liberties beyond that of the Constitution, and that's not considered a violation of the Supremacy Clause. Or it might be an instance when there is no federal law on the topic, and it might seem like a state is going rogue and doing its own thing. And so we'll get to that and explain, those situations where you would say, wait a minute, I thought we had a supremacy clause. Well, sometimes there's situations that seem like they violate the supremacy clause, but they don't. And we'll see that. And Article 7 ratification, we won't be covering that too much. That's more of a history lesson of how the Constitution could get ratified and approved by the states and become in full force and effect. And as we know, that already happened. So the reason why we even have amendments is because if you read the Federalist Papers, which were a series of newspaper articles written by the Founding Fathers, they were pretty much, promotional materials to get people to love the Constitution and approve of it. And these Federalist Papers had a very common theme where they were talking about how the Constitution could be a living, breathing document that could change with the times, which, thank goodness, there's the amendment process, because if it weren't in place, this procedure, then we probably wouldn't have survived the Civil War. So speaking of the amendment process, if you look up to the top of this slide, the method that's been used 26 times is the only one I want you to really commit to memory. A proposal by 2/3 vote or both houses of Congress, and then passage by 3/4 of state legislatures. That's the only method that's really been used with any frequency. And you can see about the other method there. So the Founding Fathers intended for this to be quite a complex process. So we didn't have the Constitution being amended, every month. But some people think it's a little too complicated. For example, the Equal Rights Amendment to the Constitution, the ERA, on behalf of women, an amendment that says that, a bunch of different wording has been proposed, but basically the amendment that says that a person's rights should not be abridged based on sex or gender has still not been added to the Constitution. We've been trying to get it passed for quite some time, especially since the 70s, and it still hasn't been passed. So we'll touch on that when we get to the rights of women. We look, as an example, at the failure of the ERA to pass to sort of critique the whole process that's exemplified in this slide. All right, so speaking of the amendments, we start off with the Bill of Rights. This slide just shows a summary of the Bill of Rights. The actual full language of the amendments that you will read this week shows that this is just a summary. It doesn't spell out all of the language of all of the amendments. But some of these will cover more than others, and we will cover them out of order, as I said. So the First Amendment pertains to freedom of speech, free exercise of religion, separation of church and state, the right to protest, what is and what isn't obscenity, all that good stuff. The Second Amendment pertains to matters like gun control, the right to bear arms. The Third Amendment we won't really cover because it's really has not turned out to be a significant amendment. The government doesn't try to force us to shelter soldiers in our homes anymore, so that won't really be covered. We will talk about the Fourth, Fifth, Sixth, and Eighth Amendments. Those all pertain to the rights of people accused of crimes. We won't touch on the Seventh Amendment because that has to do with certain rights in civil trials, not really civil rights and liberties. So, in other words, if I have a case in federal court and it's a civil case, in other words, a lawsuit, a non criminal case, I have the right to trial by jury if it's worth a certain dollar amount. So, it doesn't really have to do with the Constitution. We won't cover that. And as we go through the course, we'll cover Amendments 9 and 10. They won't be the topic of a separate focus, but they have to do with the rights of citizens and states. So the Ninth Amendment basically says that just because your rights or an idea or a theory of some right you think you might have, just because it doesn't say it word for word in the Constitution doesn't mean you don't have it. So a lot of people brought up the Ninth Amendment when the Supreme Court handed down Dobbs v. Jackson, and we'll get into that later. The 10th Amendment is similar in that it says that powers not given to the federal government by the Constitution belong to the state or to the people. This is known as sort of the default amendment. Um, you know, it basically points out that the federal government is only supposed to have a certain limited and contained amount of power. So if this document does not bestow a power upon the federal government, then it belongs to the states or the citizens. And we will see that as we go along. But make sure to read the whole language. This is just a summary, and the slide came out a little blurry. There are other amendments. We've had 27 amendments total. So after the founding of the country, we had over the years between 1795 and 1992, we've had amendments 11 through 27 passed also. So the ones that we'll focus on are the ones with the little arrows. The 13th, 14th, and 15th are amendments that are referred to as the post-Civil War amendments or Reconstruction amendments. The 13th and 15th solely focus on the rights of formerly enslaved persons. So the 13th Amendment abolished slavery, and the 15th Amendment said that you could not be denied the right to vote because of race, color, or previous enslavement status. The 14th Amendment granted due process and equal protection to all citizens, including formerly enslaved persons, and according to most historians, then granted official citizenship status on all people, regardless of race and other factors. So we'll get into those as the semester goes on. And we'll also cover the 19th Amendment, which granted the right to vote for women, which surprisingly wasn't passed until 1920. Another thing that we want to have in context before we start looking at all our civil rights and civil liberties and the amendments and all these cutting edge current events that we'll start focusing on next week is the Supreme Court itself. Who are these folks? What do they do? What power do they have? So the main power they have is what's called the power of judicial review. And the power of judicial review is the power of the Supreme Court to strike down acts of Congress as unconstitutional. And that's a right that isn't spelled out word for word in the Constitution. It's inferred. The Supreme Court kind of gave itself this right in 1802 in a case called Marbury versus Madison. But regardless of the historical context, as I speak now, the Supreme Court does have that power to interpret the Constitution, essentially determining what our rights are and striking down laws as being unconstitutional. And we have 9 justices, and we haven't always had 9. Sometimes we've had more, sometimes we've had less. We've had 9 for quite some time. And these justices get appointed by the President of the United States, and then they have to get approved by the Senate. They get appointed for life. They're not appointed just for a specific term. And when you hear the talk of packing the court, it can pertain to two different things. People use that phrase two different ways. Um, Historically, when people have talked about packing the court, it means doing what a lot of folks have said Donald Trump did, is putting a lot of people from your political party on the court when you have the opportunity to do so in furtherance of your own political philosophy. So if you look at the court and these little things that I put over their heads, I have the elephant symbol by all of the ones that are Republicans and the Democrat symbol by the ones that are Democrats. And this is me and the media and political observers giving them these labels. They haven't given themselves these labels, but there's pretty much a consensus among most people that they deserve the labels I put on them. So, for example, a lot of people have asserted that Donald Trump, quote unquote, packed the court because, see, Brett Kavanaugh here was appointed by Trump and he's a conservative Republican. The same thing with Justice Gorsuch right here and Justice Cooney right here. Um, so a lot of people said that he packed the court. Um, and you see that there's a majority because look, the other people that are also considered conservative Republicans, we have Justice Alito, who's been on the court for some time. Same thing with Justice Thomas, and the same thing with Justice John Roberts. The justices that are on the more left wing Democratic side is Justice Elena Kagan, Justice Sotomayor, and our newest justice, Ketanji Brown Jackson, who is also more on the left wing liberal side, and she's replacing Justice Breyer, who retired. So, speaking of that, the other context to the term packing the court and what that means is that some people think that when the next justice retires, which might be during the time that Biden is still in office, that not only should Biden replace them with somebody who's liberal or Democrat, but he should also go through the procedures required to have more than 9 justices to sort of have a balance between both political points of view. There's a process that has to take place before you can just increase the numbers of people on the Supreme Court, and we will get to that. So that's the other, explanation of the phrase packing the court. All right, so we also want to have some context about how the cases even get to the Supreme Court. Well, if you look at the left-hand side, you'll see that there's, generally speaking, 2 different paths that are common when a case gets to the Supreme Court. Over here on the left-hand side, this is the federal court system, and we have 94 federal district courts, and only certain types of cases can be in federal courts, certain limited amount of cases. Most cases do go through state courts, and we won't get into the details of federal versus state courts and how people decide which system the cases will start in. We'll kind of address that along the way. But in any case, we have 94 federal district courts, and say a trial happens right here where I have the mouse wiggling and somebody wants to appeal it, they will appeal their case up to this next level to one of the circuit courts of appeal that we have in this country. And we have the country divided up into 12 different circuits, and there's additional circuit for federal cases. And for example, we're in the First Circuit here in Massachusetts. And then say the person still didn't get the relief they wanted, then they would appeal the case up to the Supreme Court of the United States. And that would be the furthest that you could go. Going over to the state side, so going over to this side of the slide, we get to the state court system. And say, for example, we were in Massachusetts. Say I was put on trial for robbing a bank or something. Well, bad example because that would be in federal court. Say I was on trial because banks are federally insured. So say I was on trial for So if we talk about the state court system, that's what's on the right-hand side. And at the bottom, we have our trial courts, which, for example, say I was put on trial for some criminal matter and I felt I had an unfair trial. I was convicted. I was not guilty of the crime. I would go up to the next court, which in this instance would be the Massachusetts Court of Appeals. And then say I didn't get relief from them, I would go up to the highest court in the state, which would be the Massachusetts Supreme Judicial Court. And if I didn't get relief at that level, I could appeal to the Supreme Court of the United States. It doesn't mean that they're going to hear my case. I can write to them and ask, but it doesn't mean they're going to hear it. So that brings us to the topic of jurisdiction, which we're talking about over here. Jurisdiction refers to the authority of a court to hear a case. And that refers to both the authority over a person, to, drag them into the court, and the topic matter. Are you in the right court? So original jurisdiction pertains to instances where, for example, the Supreme Court gets to hear the cases right from the get-go, right from the beginning. They don't have to go through any other court first. It goes to the Supreme Court first. And an example of that would be when a state sues another state. And there are some other obscure examples. There's only a handful of very rare types of cases. Most cases that get to the Supreme Court are spelled out on that second bullet point. It's appellate jurisdiction, and it means they got to the court on appeal. In other words, it went through lower courts first. So again, when you look at this diagram, you see these two courts up at the top. When cases go through the lower courts and then get to them, that's through appellate jurisdiction. Another thing to keep in mind is that it's only these courts down bottom, the trial courts, where you have juries and see people present evidence and have witnesses and all of that. The other four squares, these appeals courts, it's just groups of judges looking at the record and hearing oral arguments from attorneys and analyzing whether things were fair in the lower courts or whether there was some fundamental error or thing like that. All right. So another issue with how cases actually get to the Supreme Court is the rule of four. So remember I said that, somebody who is at one of these lower levels here, I have to get back to the slide I was on. Somebody who's at one of these lower levels here, or somebody who's trying to leapfrog over from the state system, they can write to the court and hope that they'll agree to hear the case, but that might not be the case. The Supreme Court has this rule called the rule of four, which states that four of the justices have to review all the petitions that are asking them to hear the case. Four of them have to say yes in order for them to hear the case. You would think it would be five because five is a majority out of nine, but that's not the rule that they came up with. As long as four of them agree to hear the case, then the case will be heard. And they get tens of thousands of cases or requests, I should say, sent to them each year, and they only hear 1% to 2%. So keep in mind, they're not going through all of these petitions by hand. They have law clerks, usually third-year law students or recent graduates from prestigious law schools, who read all the petitions and summarize them and even do a brief summary of research and all that good stuff. And they have that to help them as they go through all of those petitions and then meet together and do a vote. And when four of them agree, um, that's when the case gets heard. And the writ of certiorari, also known as a writ of cert, is the piece of paper you want to get when you write to the Supreme Court and you're asking them to hear your case. Basically, it's a fancy phrase that means, yes, the Supreme Court is going to hear your case. So what they issue is an official document called a writ of certiorari, which is also known as a writ of cert. So the last thing I'll mention about how cases get to the Supreme Court when you're looking at this slide is that it can take years. It can take years for the case to get to them. The Roe versus Wade case, the pregnant woman in that case had already had her baby, and the baby was 18 months old. So, and that's not even the longest time it's taken. There are also limits on judicial power. So the Supreme Court can't just hear any old case in any old situation they want. The ideas on this slide are spelled out further in chapter 2. So if it seems like I'm going through them too quickly, you can go read the chapter. But basically, there has to be an actual legitimate live case or controversy for the Supreme Court of the United States to hear a case. So mootness would bar the court from hearing your case. So, for example, say there was some hypothetical law in some state that was violating some certain constitutional right of mine, and I wrote to the Supreme Court, and in the meantime, the state decided on its own to wipe that law off the books. Then the Supreme Court would not issue me a writ of certiorari because they would say the point is moot. Or if you watch Friends, as Joey would say, the point is moo. But seriously, mootness is something that would bar the Supreme Court from hearing a case. Once in a while, they will violate their own rule on this because either the case they're considering pertains to a whole bunch of people that have like a combined case, and other people might still be harmed, or there's an instance where this issue could keep repeating itself in the future. So there are some exceptions to this mootness thing that we'll see. Ripeness is similar, but not exactly the same. Say again, I was this hypothetical citizen living in a hypothetical state, and some hypothetical law got passed that was going to violate a constitutional right of mine, but I was never arrested or affected by the law, or it never harmed me in any way, right? There was a law on the books that had actually never been put into full force and effect and harmed me. So the Supreme Court would say that it wasn't ripe, and ripeness would bar them from hearing it. So they couldn't issue me a writ of cert even if they wanted to. Standing is also important. In order for me to write to the Supreme Court and ask them to hear my case, I have to actually be the one being harmed, even if I'm concerned for a friend. If it was my friend being harmed and having their rights violated, they would have to be the one, and their attorneys, to bring the case to the court. Advisory opinions and political questions are pretty similar. I'm not going to get into those too much because those don't come up too often. Basically, if I was a representative on the Massachusetts state legislature and I was wondering if some law I wanted to pass would violate the Constitution, I couldn't write something to the Supreme Court and ask them to write this big fancy opinion telling me yes or no. They're not going to issue advisory opinions. Some state Supreme Courts will do that, though, when their own state lawmakers ask them to. This is just the Supreme Court of the U.S. And political questions are largely the same. Excuse the lawnmowers in the background. I'll just talk louder. And state action is something that it isn't really, if I remember correctly, spelled out in chapter 2 is one of their bullet points. It's just sort of, um, you know, uh, something that goes on in the background as far as when the Supreme Court will hear things and won't hear things. So, for example, if I felt my constitutional rights were being violated because I was an African American person and I wanted to join the KKK, which, I mean, how would that ever happen? That's ridiculous. But anyway, hypothetically, say I wanted to join the KKK and they said no because of my race. Well, I couldn't sue the KKK and bring it up before the Supreme Court because the KKK is a private entity. It's not the government violating my civil rights and liberties. Um, so that's why certain social media platforms can bar certain people from their platforms or bar certain content. And that's becoming controversial because some people say that they've taken on a um, public character and that they're regulated by the government. So it should be considered state action when a social media platform violates the First Amendment, but we haven't gotten there yet. So for now, when private entities want to be discriminatory, they can. The only exception to that, really, and we'll see this when we get to the civil rights era, is that you can't have, whites only diners and things like that. Even though they're owned by private companies, it's considered a violation of interstate commerce. So we'll get to that later on in the semester. All right, the next concept we'll get to is one that you'll see come up again and again in cases, this phrase, incorporation doctrine, and you'll keep saying to yourself, what do they mean by this? Because it can be a little convoluted. Basically, what the incorporation doctrine about is this. Back when the Constitution was first written and you looked at the Bill of Rights, it might surprise us now to hear that the founding fathers and everybody involved only intended that list of 10 rules, that list of 10 do's and don'ts, because that's what they are. They're a list of telling the government what it can and can't do, not us. Those were only intended to be marching orders for the federal government to abide by. Believe it or not, they weren't considered marching orders or an authority over state governments. So, hypothetically, a state government could come up with a law that violates the First Amendment to the United States Constitution. So, as time passed, we realized that either that wasn't probably the true intent or shouldn't have been, or there's lots of arguments about that. But starting in the 1920s and really culminating when the 14th Amendment was passed shortly after the Civil War, the popular mindset among the people on the Supreme Court and our lawmakers and even our citizens was that, hey, state governments should have to abide by the Constitution too. In other words, no state should come up with a state law that violates any of those amendments. So, as it stands now, there still is some controversy over whether or not all of the amendments have been incorporated. In other words, whether all state governments have to abide by the interpretation of the Supreme Court of the US when it comes to civil rights and civil liberties. So when we go through the course, you'll see that it's been addressed in a patchwork quilt-like fashion. There'll be one part of one amendment where the Supreme Court will say states definitely have to follow this. And then we'll see another part where that's not true. So the best way to think about it is to look at the actual language of the 14th Amendment. Look at the language in black font that's bolded. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So that's one part of the 14th Amendment, and that's the part that everybody points to when they say, if there's any doubt about whether or not states have to abide by every single syllable of all of these amendments, I mean, look at that. Doesn't that make it clear? Some people think it doesn't make it that clear. So, again, if this is still confusing to you, look at the chapter There's one whole chapter dedicated to the incorporation doctrine, and you can get to that through the link to your free textbook. It's a link on the Blackboard shell, and you can jump right to the incorporation doctrine chapter through a hyperlink in the table of contents. You don't have to scroll through. But when people talk about selective incorporation versus total incorporation, they're referring to this controversy I'm talking about. So if I was a selective incorporation person, I'm sorry, my dog's mental. If I was a selective incorporation person, I would say not all of these clauses from all these amendments apply to the states. Only certain ones do. And if I was a total incorporation person, I would say, look at the language in bold. All states have to apply by every single syllable of every single amendment. And the reason behind all of this is states' rights, right? If I'm somebody who really believes in states' rights, or I disagree with the way a certain amendment is interpreted, then I'm going to be more of a selective incorporation person. But if I'm somebody who's in favor of uniformity and isn't so much of a states' rights type of person, I would be leaning more towards total incorporation. So if this concept still confuses you, come to office hours or shoot me an email. I can link another article or look at that chapter. Now, as far as current events we're going to learn about, you might be concerned about or interested in learning about the ones that are on the slide, and we will get to them sooner rather than later. We're definitely seeing a trend where we're having more conservative justices on the Supreme Court and more conservative interpretations of our Constitution taking place. So what I'm saying isn't really that controversial. I mean, even people who are very conservative Republicans, even if you were to go on Fox News, they would agree, we're getting more conservative rulings handed down. The only difference is the people on Fox News would like these interpretations, and then on CNN, they probably would not like these decisions. Not probably, they wouldn't like these decisions being handed down. So there's really no dispute about the current trend we're seeing, that it's actually taking place. The dispute is about whether or not we approve of these outcomes. So the Dobbs versus Jackson case is one that we'll look at next week. That's the case that overturned Roe versus Wade. And we'll look at that next week when we look at the right to privacy and reproductive rights. And we'll look at these other cases that are mentioned on the slide when we get to those topics. All right, as far as our wrap up, if you're ever in doubt about something, please don't hesitate to shoot me an email, but look in the syllabus first, because the answer to whatever your question is probably in there. Please do make sure to look at the entire Constitution this week. It is linked to your weekly folder. The reason why I have number 3 there, reading is fundamental, so are the videos, is because I'll get emails asking about a certain question, and the question will be presenting some difficulty to somebody because they were just trying to read the question and Google the answer. But if you do the readings and go through the videos, the answer will be there. Please make sure to use your Mass Bay email to get in contact with me, because our filtering system will bounce the email back to you and sometimes won't even let me know you sent it. And the last few things is, don't be afraid to use the office hours, and we will get to the current events as soon as we can. All right, so go on now to look at test 1 and discussion board 1. And I will post the video for next week soon.